AI really is finding itself into absolutely every industry and really solving problems across industry and across the world. But I'm going to focus on the easier stuff today, which is where we are in relation to patentability of AI-augmented inventions made by humans. Fundamentally, we have to describe, to get past the European exclusions from patentability, to deal with the constraints on any added subject matter after filing, every European patent attorney understands the need to fully describe a technical implementation in detail and to tell the story about the technical applications of the invention. So European practice on patent drafting already helps us, and frankly, it must be one of the easiest applications for AI to be self-describing. If the AI system is keeping track of its own processing as it goes, surely that can generate part of the description for us that we can include within patent specifications. Well, what about inherent patentability? What about all these exclusions from patent protection that we find in the European Patent Convention and that we see the US applying with Section 101 of the US Code? Surely mathematical methods are one of the most clearly identified unpatentable things, and certainly previous practice has focused on that as a problem, a really clear exclusion from patentability in Europe of mathematical methods and computer programs, and therefore, apparently, computer implemented mathematical methods, which is a lot of what we're talking about with machine learning solutions. Well, maybe that's not so hard either, and I'm pleased to say the European Patent Office has recently issued some updated guidelines on the 1st of October. They will be effective from the 1st of November. So European Patent Office examiners will have a slightly different approach to patentability of computer implemented mathematical methods, because the guidelines have been written to encourage them to think about things slightly differently. The guidelines of themselves need a bit of analysis, but I think it's important to mention that they were developed following a period of consultation that the European Patent Office has had with industry, with the judiciary, with academia, and a few people like me. So it isn't just an update of the European Patent Office guidelines to reflect recent case law developments. There is a discussion that's taken place about what does industry want, and there's been a discussion with the judiciary about, if we grant patents with this breadth of claim, will you throw them out? So the EPO has struck a balance in there between what would be maintained as valid in courts in Europe and trying to achieve something that is satisfactory across industry. So where fundamentally do we have to go to achieve this sufficiency of description and bypass the exclusions from patentability for mathematical methods that are still there in Article 52, Part 2, very explicitly in the European Patent Convention? And the answer is that we really need to be making sure we do focus on specific technical applications of AI or specific technical implementations of AI. And frankly, when you're writing a patent specification, well, let's include both if we've got them. I'd like to suggest to this room that Europe is actually quite well prepared for AI patenting at this point in time. The case law or computer program patentability has been pretty stable since 2010, when the EPO's Enlarged Board of Appeal basically told us which case law they were going to refer to. We've had a lot of success in computer-related inventions both at the UKIPO and at the European Patent Office. They don't follow identical processes, but they often get to the same result. And you might be surprised how many software implemented inventions are granted by the UK Intellectual Property Office these days, as well as at the European Patent Office. And specifically, these new guidelines that have just come out will be effective from 1st of November, highlighting the specific technical applications and specific technical implementations as the criteria for patentability of computer-implemented mathematical methods. Now, just to emphasize a few small points from these new guidelines for mathematical methods, they used to begin in a rather discouraging way. Section 3.3 of Part G, Chapter 2 of their guidelines, mathematical methods are a particular example of the principle that purely abstract or intellectual methods are not patentable. Not very encouraging. They now start, mathematical methods play an important role in the solution of technical problems in all fields of technology. Well, that's a bit more encouraging. And when you go on to the specific detail of those guidelines, we've got a reminder, based on the EPO case law, that the assessment of when assessing inventive step, all features which contribute to the technical character of an invention must be taken into account. So you may be aware that the EPO has this approach of disregarding, when assessing inventive step, features in a claim that they think are non-technical. Well, if it's relevant to the technical character, it has to be considered relevant to inventive step, and they say explicitly, a mathematical method may contribute to the technical character of an invention by its application to a field of technology or by being adapted to a specific technical implementation. And the guidelines themselves do tell us the types of application that the EPO management is now instructing their examiners to accept as being patentable if the claims are functionally limited to a particular technical purpose. There is a section on artificial intelligence, but it's really just a brief introduction to the topic at this point in time. The important thing to note is probably the last sentence of this slide that just says the guidance provided in G2 3.3, i.e. the section on mathematical methods, generally applies to a lot of artificial intelligence and machine learning technologies and patent applications. So they give the examples of what they think AI is, and they talk about computational models and algorithms, and give the examples of neural networks, which actually they've been patenting at the EPO since 1992, the year I joined IBM. There was an article from the EPO on patenting of neural networks, and genetic algorithms and so on. Also worth mentioning, I think, that just at the end of September, we've seen some encouragement from the US Patent Office. So this was from the USPTO Director Anku at the IP Owners Association meeting, where he'd highlighted a recognition within the USPTO that more needs to be done. They've got to fix the problem of an excessive number of objections under their Code 101 when things are identified as abstract and unpatentable. So a growing consensus that it needs to be dealt with. But what was interesting is he starts to talk about how the European approach, he doesn't use that word, but the European approach seems to be something that he has some sympathy for. So the middle paragraph on this slide, he's saying if it's non-obvious enough to get past the lack of inventive step objection, if it's novel, if it's got a sufficient description, can we really say that there's nothing in there that's concrete enough to get past Section 101? Well, that's the European test. There's very little that is excluded from patentability if we write our claims as a computer-implemented method or a system that's implementing a mathematical method. But in the US, there's been a practice since 2014 of knocking out a lot of cases that appear to us to be recited as technical implementations. It looks like Director Iancu is planning to change things. And he does go on to talk specifically about how the exceptions should capture only those claims that the Supreme Court has said remain outside the categories of patent protection, despite being novel and non-obvious and well disclosed. Another thing to mention for those of you who are not in the IT industry and haven't had to think about computer program patentability and AI technologies in the past, the EPO has recognised the need to be training its own staff in their life sciences chemistry teams, in their automotive and other mechanical engineering teams to focus on software patentability case law so they can apply that now across all technologies. Thornton's been doing the same. We're making sure everyone across our business understands software patentability, mathematical method patentability.